This is Aaron Spencer, who is charged with murder after he allegedly chased down and killed the man who absconded with Spencer's teenage daughter. Last October 8th, 2024, Aaron Spencer and his wife woke up because their dog was barking. This was unusual, so they went and checked their 14-year-old daughter's room and found her bed empty except for a stuffed animal dressed in a hoodie. Aaron and his wife Heather looked all over the house for the daughter. They called family, they called friends. When they could not immediately find her, they called 911. Aaron Spencer gets on the phone with Lonoke County 911 and he tells them his daughter is missing. And then Aaron gets in his truck and starts driving around looking for his child. And very quickly he comes across Michael Fossler's vehicle with his daughter inside of it. Not only was the Spencer family already aware of Michael Fossler, he was actually out on bond after allegedly previously abusing the teenage daughter. Allegedly, Fossler was a boyfriend of a family friend and he gained access to the child and got her cell phone number. And Michael Fossler, who was 66 or 67 at the time, continued communicating with this girl until eventually he began to physically assault her. And in June of 2024, he was arrested on 43 counts, all affiliated with this teen girl, including internet stalking of a child, among other horrifying things. Fossler had been released on a $50,000 bond and he was given a no-contact order for the Spencer family. He was not to communicate with them or their child at all whatsoever. So fast forward to October 8th, where the Spencers cannot find their daughter, and when they do find her, she's in the vehicle of a man who's been allegedly abusing her. Spencer said that he saw Fossler's Ford F-150 heading toward Fossler's home, and Spencer started flashing his lights, honking his horn, trying everything to get Fossler to stop. He says that when Fossler wouldn't stop, he rammed his own truck into the back of Fossler's, pushing him into a ditch. Spencer said that he got out of his truck with his firearm in his hand, a Glock 19 Gen 4. He says he was pointing his weapon at Fossler and ordering him to lay in the ditch, but that Fossler lunged at him, yelling, "Fuck you." At that point, Spencer emptied his weapon into Fossler and apparently pistol whipped him afterwards. Then he retrieved his daughter and called 911 to tell them what had happened. Aaron Spencer had been put into a police cruiser on the scene. Later, he was taken out of the police cruiser and then put back in on the other side of the police cruiser. And he said the second time he got into the police cruiser, he saw a glass smoking device in the car. Immediately, Spencer demanded a blood test to confirm that he was not a drug user. And at that time, the state did not file any charges about the glass smoking device. Spencer said that he had noticed the device and immediately notified officers that it was already inside the cruiser when he was placed there. I do think it was very smart of Aaron Spencer to immediately request this drug test to prove that he was not the owner of this item. And his lawyers point out that the Arkansas State Crime Lab testing of the device yielded a partial male DNA profile that affirmatively excluded Aaron Spencer. I'd also like to add that I personally find this whole glass smoking device weird, because even if Aaron Spencer did have it on his person, does that mean these police officers just didn't pat him down before putting him in the police car? And also, allegedly, as he's leaving to go save his daughter, he's like, let me just stop real quick and grab a glass smoking device. Anyway, lawyers have requested that this not be brought up in court. When Aaron Spencer was first arrested, he was charged with first-degree murder. Later, they downgraded that charge to murder in the second-degree felony with a firearm, and Spencer's case was assigned to Judge Barbara Elmore. Judge Elmore had also been assigned to Michael Fossler's case. I'm not sure if he was retired or what at the time that he died, but previous to this, Michael Fossler had been a police chief in Indiana, and so there's been some speculation about if his police status had anything to do with him being let out on only a $50,000 bond, even though he had 43 charges against him. I do need to do a little bit more research to see what's typical for that type of charge, though. The day after his arrest, Spencer was released on a $150,000 bond, and in December, his counsel files a motion saying that Spencer is going to use justification as a defense. They're basically going to argue that Spencer had to use deadly physical force to prevent further crimes happening to either him or his child. In Arkansas, a person is justified in using deadly physical force if they reasonably believe that the other person is committing or about to commit a felony involving physical force or violence, if they are using or about to use deadly force themselves, or if they're imminently endangering a person's life or imminently about to victimize a person in a pattern of domestic abuse. Since the beginning, the social media posts about this have been hailing Aaron Spencer as a hero. They say that he stopped a pattern of abuse against his own child. And in response, attorneys for the state of Arkansas submitted a motion for a gag order. They said that calling Aaron Spencer a hero could prejudice people against being able to find him guilty of murdering Michael Fossler. So on the 4th of December, they submit the motion for the gag order, and Aaron Spencer's team asks for 14 days to respond to it. The court is like, you can have 5 days. And they successfully put their 19-page reply together in just 5 days. And only moments after it's entered onto the docket, the judge grants the gag order. She does not hear oral arguments about it. I honestly don't even know if she had time to read their response. And this gag order is intense and it's broad. They're like, no attorney or agency connected with this case can talk about, but also judicial employees, officers of the court, or any public official holding office, including the law enforcement officials or agents, deputies, or employees of any such persons, all also cannot talk about it, which is a whole bunch of people who are not affiliated with this case. And lastly, in a handwritten note, she adds that his family may not discuss it either, this is very broad. All parties and the defendant is under a gag order. This order will help ensure all parties get a fair trial. The entire case is now sealed. So not only does she grant the gag order, but she also seals the case, which means the public can't see documents, etc. about it. Spencer's counsel is like, absolutely not, and they appeal this to the Supreme Court of Arkansas. And in a scathing filing, they vacate the gag order. We cannot fathom why the circuit court believed it could prohibit the speech of any public official now holding office. In fact, it's difficult to foresee any circumstance in which a prior restraint on the speech of a member of the public, which would include a public official, could be constitutional. Not only did they agree to this as a group with a majority opinion, but two different justices also wrote concurring statements. Justice Wood saying that you don't even have to go to the U.S. Constitution to see why this is a problem. It's a problem within the state constitution itself. And then Justice Brawley closing out with this statement. I join the majority's decision in granting the writ and vacating the gag order, but I would go a step further. The repeated attempts to veil these proceedings in secrecy can only breed ignorance and distrust of the courts and suspicion concerning the competence and impartiality of the entire criminal justice system. Tell them! He says the sweeping order is only one part of a troubling pattern of attempts to shield this case from public view, beginning with the non-public arraignment and ending with those handwritten notes sealing the entire case from public view. We cannot allow that pattern to continue unchecked, so I'd like to invoke this court's superintending authority and reassign this matter to a new circuit court judge. Is there not another judge that could handle this? Anything else suggests that what's happened so far is within the acceptable range of disagreement or administration, and it isn't. The circuit court entered the gag order just 6 minutes after the clerk docketed the defendant's 19-page opposition to the state's motion, or barely enough time to make a pot of coffee. That approach cannot be squared with the First Amendment, and it underscores that the gag order wasn't a last resort but an unconstitutional impulse. The same circuit court judge that issued the gag order here also granted Michael Fossler's release on bail. It's that decision, which the defendant's lawyers call the decision to release a predator who repeatedly violated the defendant's child on a low bond, that set off this chain of events that led to the fatal confrontation that's the subject of this case. I believe the prosecution's biggest argument in this case is going to be that if he had just called 911 after finding Fossler's truck, instead of running Fossler off the road, that the police could have come and handled this situation. But also, depending on the jury, they might see a family that had relied on a court system before that had failed them. There is no question that Michael Fossler violated his no contact order. And I know I've said allegedly quite a lot in this situation. That is to protect me legally. That is, me saying allegedly doesn't mean I don't have firm beliefs about some things to do with it. That is essentially the information we have now. I don't know if the Arkansas law is going to apply to him in terms of justification. I will say I do believe that him and his wife have both made statements saying that they believed that Fossler was going to end their daughter's life that evening. Fossler was scheduled to go to either a hearing or maybe a trial in December, but he was scheduled to be back in court in December, about 2 months after this all happened. So was he seeing the end of the road for his freedom? Why would any 67-year-old man need to contact a 14-year-old child they're not related to at 1 o'clock in the morning? And as somebody who has children, genuinely could not tell you what I might do or feel in this situation. Aaron Spencer has a hearing scheduled for August 8th, and his 5-day trial is scheduled to start on September 22nd. Originally, these trial dates were scheduled for a couple months ago, but both the defense and the prosecution agreed to a continuance to move it back to September. That is everything for now. Love you guys. Drink water. Bye!